At some point between paying your monthly bank statement, opening a medical bill, reviewing your credit card summary, and sorting through a stack of notices that all seem to want money from you, a quiet and deeply unfair thing happens. You pay. You pay because the bill arrived, and paying bills is what responsible people do. You pay because questioning a fee feels confrontational. You pay because nobody told you that a significant number of the charges appearing on your statements, your medical paperwork, and your financial accounts are either legally unenforceable, routinely waived upon request, or outright prohibited by federal consumer protection law when applied to people in your specific situation. Today, that changes. Because if you are a woman over 70, there are 6 categories of fees that attorneys, financial advisors, and consumer protection specialists will tell you directly. You are not required to pay them, and millions of women just like you are handing over money every single month that legally or practically does not need to leave their hands. The first fee is one that appears so routinely on bank statements that most people have stopped noticing it. Monthly maintenance fees, sometimes called service fees or account fees, are charged by banks on checking and savings accounts when the account does not meet certain balance thresholds or activity requirements. These fees typically range between $10 and $25 per month at major national banks, which means over the course of a year, a woman paying a monthly maintenance fee is spending between $120 and $300 simply for the privilege of keeping her money at an institution that is simultaneously using her deposits to generate profit. What banks do not advertise is that virtually every major financial institution in the United States has a designated account tier specifically designed for customers who receive Social Security income via direct deposit. And those accounts carry 0 monthly maintenance fees as a standard feature. Beyond that, federal credit unions and community banks often maintain senior accounts with no balance requirements and no monthly charges at all. The fee is not inevitable. It is a default applied to customers who do not ask for an alternative, and asking takes a single phone call to your bank's customer service line, during which you tell them you receive Social Security by direct deposit and you would like to be moved to the account that does not carry a monthly charge. Most banks make that change immediately without resistance. The second fee is the credit card late fee, and this one has a legal dimension that most cardholders are completely unaware of. The Consumer Financial Protection Bureau finalized a rule in 2024 that caps credit card late fees at $8 for large financial institutions, down from previous allowances of up to $32 for a first offense and higher for subsequent late payments. While legal challenges from the banking industry have temporarily delayed full implementation of that cap, the underlying legal authority of the Consumer Financial Protection Bureau has been affirmed by the Supreme Court of the United States in a 7-2 ruling. Beyond the regulatory changes, every major credit card issuer in the country maintains an internal policy allowing customer service representatives to waive late fees for cardholders who have a reasonable payment history and who call to ask. Studies of consumer behavior consistently show that customers who call and request a fee waiver receive one more than 80% of the time. The fee is charged automatically by software. It is removed manually by a human being when a human being calls and asks. If you have paid a late fee in the past 12 months and you have not been habitually late on your payments, you left money on the table. The third fee is one that lives inside your medical billing and has a federal law dedicated entirely to eliminating it. The No Surprises Act, which took effect in January of 2022, prohibits healthcare providers and facilities from billing patients for out-of-network charges they did not agree to in advance. Before this law, it was common for a patient to have surgery at an in-network hospital, consent to all the costs they were aware of, and then receive a separate bill weeks later from an anesthesiologist, an assistant surgeon, or a laboratory technician who was not in their insurance network and who charged rates dramatically higher than what insurance would cover. That practice is now illegal in most circumstances without explicit written consent from the patient obtained before the service was rendered. If you have received a surprise medical bill for out-of-network services you did not specifically authorize, you have the right to dispute it. You start by calling your insurance provider and specifically referencing the No Surprises Act and your right to independent dispute resolution. Many of these bills, when challenged, are either significantly reduced or eliminated entirely. The fourth fee involves your prescription drug costs, and it specifically applies to women over 70 who are enrolled in Medicare Part D. The Federal Extra Help Program, also called the Low Income Subsidy, provides assistance covering Part D premiums, deductibles, and co-payments for people who meet income and asset guidelines. The income limit for this program is approximately 150% of the federal poverty level, which for a single person translates to roughly $22,000 or less in annual income. Millions of seniors who qualify for this program are not enrolled in it because they have never applied and no one has ever mentioned it to them. If you are paying monthly premiums for a Part D drug plan and paying co-payments for medications, and your income falls within the qualifying range, you may be entitled to have those costs reduced to near zero. The application is handled through the Social Security Administration, either online at ssa.gov, by phone, or in person at your local Social Security office. The fifth fee is one that people rarely connect to legal protection because it arrives not from a current creditor, but from a collection agency attempting to recover an old debt. Every state in the United States has a statute of limitations on debt collection, a legally defined window of time during which a creditor or collection agency can sue you in court to recover what is owed. Once that window closes, the debt is considered time-barred, and while the debt technically still exists, the creditor has lost the legal mechanism to enforce it in court. Statutes of limitations on consumer debt vary by state and by debt type, but generally range between 3 and 6 years from the date of last activity on the account. If you are over 70 and you are making monthly payments to a collection agency on a debt that is 7, 8, or 10 years old, there is a strong possibility that debt is time-barred in your state and that you are voluntarily paying something no court could compel you to pay. Consulting with a consumer law attorney, many of whom offer free consultations, will tell you within minutes whether the debt you are paying is still within the enforceable window. Additionally, under the Fair Debt Collection Practices Act, collectors are prohibited from using deceptive, abusive, or misleading practices to extract payment, and any collector who falsely represents the legal status of a debt is violating federal law. The sixth fee is one that touches the daily life of women over 70 who are managing utility costs on a fixed income, and it is a fee that a collection of overlapping federal and state programs exists specifically to eliminate. Reconnection fees, late payment penalties on utility accounts, and energy surcharges are routinely waived or covered for qualifying low-income seniors through the Low-Income Home Energy Assistance Program, known as LIHEAP, a federally funded program administered at the state level that helps eligible households pay heating and cooling costs, avoid disconnection, and cover past due balances that have accumulated on utility accounts. Eligibility is generally based on income relative to the federal poverty level or state median income, and seniors living on Social Security alone frequently qualify without realizing the program exists. Beyond LIHEAP, most major utility companies, electric, gas, and water, have their own internal senior discount programs and hardship assistance programs that are not advertised on bills but are available by calling the company's customer service line and specifically asking whether a senior assistance rate or payment assistance program is available for your account. Utility companies would far rather work out a reduced payment or fee waiver than deal with disconnection, reconnection logistics, and the regulatory scrutiny that comes with cutting off power to elderly customers. Now step back for a moment and look at what these 6 fees have in common. Every single one of them is paid most often by the people who can least afford to pay them. Every single one of them is reduced, waived, or eliminated most often for the people who know to ask. And every single one of them persists in the financial lives of millions of women over 70, not because those women are foolish or uninformed, but because the systems that generate these fees are not designed to inform you of your options. They are designed to collect. The bank's software does not prompt you to switch to the senior account. The credit card company's billing cycle does not include a note suggesting you call to request a waiver. The collection agency's letter does not mention that the debt may be time-barred. The utility bill does not list the assistance programs available on the back. You have to know to ask, and now you know. Please share this video with every woman you know who is over 70 and managing finances on a fixed income, because the information in it is worth real money on a monthly basis. Subscribe to this channel right now if you want to keep receiving the kind of clear, specific, no-nonsense guidance that actually changes what lands in your bank account. There is considerably more coming, and every video on this channel is built around one simple principle. You deserve to know exactly where you stand.